Welcome to class 26 of secretarial practice. In this class, we are going to study regarding doctrine of constructive notice. So, what is this doctrine of constructive notice? So, it is also called as constructive notice of memorandum and articles. Okay, so memorandum and articles of the companies, so these are the documents. So documents, they are not only the documents but they are the public documents on registration with the registrar. So these are the public document at the time, so as it gets registered with the registrar of the company, and when we say it is a public document, this document is kept open for the public for inspection in the registrar office for the payment of some prescribed fee. Okay, so this document, this memorandum of association and articles of association of the company, so this can be observed, this can be read by the public, so which is kept in the registered office. So you can go through these two public documents. Okay, so every company which are dealing with the company, so they should know what are the contents are there in these two documents. So which documents? The articles and memorandum of association. Okay, these two documents. So these two documents construct, or technically we can say this is a doctrine of constructive notice. So I repeat, the two main documents which are prepared by the company is articles and the memorandum of association, and these two documents are kept in the registrar office. Okay, so these two documents we call it as a public documents. As we call it as a public document, so these documents are kept open for the public to have an inspection over it. Okay, so it is said that if the company wants to deal with if the person wants to deal with the company, it is necessary that they have to go through these two documents. So which documents? Memorandum of association and articles of association. And these two documents together or collectively we can say, technically we can say, it is called as doctrine of constructive notice, or it is known as a constructive notice of memorandum and articles of association. So it is assumed that, or we can say, we can presume that if it is, or if the individual is dealing with a company, he have already read that document. Okay, so always presume that the individuals dealing with the company, so they have not only read it but also they have understood the proper meaning, so which is there in the memorandum and articles of association. Okay, so naturally if a person enters into the contract, so which is beyond the power of the company, so power of the company is been stated in this document, right? So what the company have to do, which type of activity it can carry out, so all these things, and what are the rules and regulations, so this is been carried, or this has been included in the articles and memorandum of association. So normally what happens, if a person enters into the contract, so in which contract, so the company is acting beyond the power, so he cannot acquire the right under the contract against the company. So what happens, if the person is going to enter into the contract with the company, so the contract is beyond the powers which is given to the company, beyond the powers which has been defined in this memorandum and articles. Okay, so now if the person is going, or if the person is suffering some loss, in such case what happens, the person cannot claim, or we cannot say they don't have the right to acquire the loss which is suffered by him against the company. Okay, so we can say with a simple example that where the articles provide that the check issued by the company must be signed by two directors. Okay, if the person is going to deal with the company, so he should read the documents and he should understand the document, right? So he should not accept the check with only the signature of only one director. Okay, so it is clearly given in memorandum and articles of association that suppose you are going to sign, or if you are going to get the check, it should be signed by two directors, otherwise you should not accept the check. So if he accepts the check signed by only one director, he is at fault now. So it is his mistake, and as such he cannot claim any right against the company. So he cannot claim for the loss what is been suffered by him from the company. So what happens here? So in simple we can understand the doctrine of constructive notice or the constructive notice of memorandum and article is protecting the company from outsiders, right? Protecting the company from outsiders. So it is presumed that if the person dealing with the company should read the memorandum of association and articles of association, and if they have not read that, so who will be at default? So who will be the fault? The person who is going to enter into the contract, but not the company. The next is doctrine of indoor management. So this rule of indoor management is an exemption to constructive notice. So what happens in constructive notice? Constructive notice protects the company from outsiders. So here indoor management says it is an, or we can say it is, we can say it is just opposite to your constructive notice. So constructive notice protects the company from outsider, but here in indoor management we are going to protect the outsiders from company. Okay, so it is said it is an exemption to the constructive notice. It protects the outsiders from the company or the act done by the company. So under this indoor management, person dealing with the company are presumed to read, right? So we say they have to read the memorandum and articles of association, but they are not bothered about the internal proceedings, right? So it is not the duty of the outsiders to see what the internal proceedings is going on in the company. Okay, so it is said that they have to read the memorandum and articles, and once they are satisfied with the company has a power to enter into the proposed transaction, they are required to do no more, which means they have understood that the company has a power, but they are least bothered about what are the internal proceedings of the company. So this we call it as doctrine of indoor management, or the rule we can say. The doctrine of indoor management is a great importance to the person dealing with the company, because the absence of this doctrine, the company could avoid its liability on the contract entered into, so with the outsiders. So for example, the articles of the company states that the directors of the company are empowered to borrow the money from outside subject to passing the resolution in the general meeting. Okay, so here the directors borrow money from X but without passing the resolution in the general meeting. By the virtue of doctrine of indoor management, Mr. X is safe. Why? So it is given in the memorandum articles that the company should, or the directors can borrow money by passing the resolution in the general meeting. Whether they are going to conduct the general meeting, whether they are going to pass the resolution, so it is least bothered. So it is given in the articles and it is read by the person who is going to enter into the contract, so he is safe. So it is the duty of the company directors so that they have to conduct the meeting. Okay, they have not conducted, so it is their responsibility, so they are liable. Mr. X is safe here. Okay, so he can recover the money from the company as it is not bound to inquire into the regularities of the internal proceedings. So there are some cases relating to the doctrine of indoor management and doctrine of constructive notice, and also the last case the ultra virus, right? The doctrine of ultra virus and all. I said I am going to explain you the case. So that case I am going to give you later. Okay. So there are some exemptions to the doctrine of indoor management. So one is your knowledge of irregularities. Okay. So here the person cannot claim any protection under the doctrine of indoor management. So if he has a full knowledge regarding the irregularities in the internal proceedings of the company, so he has the knowledge that there is some irregularities, and if he is going to enter into the contract and suffer the loss, so such person will not or cannot claim. Then the next is negligence. So where he has not made the proper enquiry, suppose he has not made any enquiry despite of some suspicious, so he has some doubt, but he is not going to make an enquiry and he is going to suffer the loss. So what happens is not able to claim for any protection. Okay, suppose if he feels where he is found to have relied upon the forgery document, so if the document itself is forged, so he is not liable, the company is not liable and the person cannot claim for it. Okay, so the next is where he has no knowledge of company's memorandum, articles and association, in case the knowledge of this document is warranted, or we can say representation by articles. So if he do not have any knowledge regarding that and if he is going to enter into the contract, so he cannot claim for that. The next is where the contracts enter into with him by any officer of the company is beyond the limit of the authority. So if any act done with beyond the limit or the beyond the authority, so then we can say it is not, or we can say the person cannot claim for any protection. Thank you.